Hi friends, today we are looking into an important issue of polity. It is with respect to intricacies of pardoning powers of both president and governor, and a case study under Perarivalan judgment. Last month, Supreme Court has given an order, and in that order it has used its extraordinary power under Article 142 to release the convict in Rajiv Gandhi assassination case, Perarivalan. And the Supreme Court has not just used 142 under this particular case, but it has also used the Article 142 in other cases also. And lot of people are having some confusion regarding what is this pardoning powers, when a president of India will award this pardoning power, or when governor is exercising his power, and what is this particular case, why Supreme Court is intervened. Apart from knowing the facts of this case, lot of constitutional issues are involved in this, and those issues we are going to discuss in today's class. And to understand those issues, I will give some historical background of this case, and I will put those questions and I will try to explain answer to those questions. It's not answers, but are all intricacies, and these are all debatable points. But you must understand, like, lot of technicalities and nitty-gritties are involved in this particular case. So first of all, I will put some questions, and later I will enter into the history of this judgment, and later I will try to explain. See, when this judgment has delivered in the month of May, that means in the last month, all the newspaper has carried articles and editorials by saying this is a win of federalism. Some people say it as liberty, but most of the people quoted it as the federalism. So how federalism is involved in this case, and how the role of governor has become controversial in this case, and how this federalism has violated in this particular case, what is the role of president that he could have done. And it is not just about the role of governor and role of president, but it is also about the executive jurisdiction of both union and state. So I will mention here the role of governor, president, federalism, executive jurisdiction of both union and state when a case is investigated by the central agencies like CBI. Now the concurrent powers, if both constitutional and statutory powers, if both are applied at the same time, then how that issue will be decided. Next, it is the procedure established by the law versus a national security. Next, the another important aspect is misuse of constitutional provisions to curtail the individual freedom. So these seven aspects are there in this particular issue. So what is the role of governor, what is the role of president when you are exercising this pardoning powers under Article 72 by the President of India, under Article 161 by the governor of any particular state, and how come this issue federalism came into this, and what is this executive jurisdiction of both union and state when a particular case is investigated by the central agencies, and another is the constitutional and statutory powers, if both are exercising at a particular time, that means simultaneously, then which one prevails, and the procedure established by law versus national security, and another one is misuse of constitutional provisions to curtail the individual freedoms, Another one is usage of this article 142, because this is an extraordinary article. So is it an overreach of judiciary? Is it an overreach of judiciary? I will come to the each and every aspect of this 8 points, and these are all very important things, because you may get a question on any of these things, and if you get a question on any of these things, you can quote this judgment or you can quote this particular case. Okay, so now I will come to the little bit history of this case, and all the people, you are already having an idea on this Perarivalan. He is a person, is not alone, and he along with some other people involved in the assassination of former Prime Minister Rajiv Gandhi in the year 1991, and immediately they have arrested, and in that some people have given death sentence, some people have given life sentence, around 4 people have given a death sentence, but the sentence has not happened immediately. The judgment was delivered, the issue was happened in the year 1991, the judgment was delivered in 1999. In the year 1999, Supreme Court convicted them and awarded death sentence to some people and life sentence to some other. Now after that, the one who got this death sentence, they have approached the President of India, for getting this. They applied to the President of India with their mercy petition, because President of India can only commute that sentence, and that is why they approached the President of India. And when you are exercising, when the President of India and Governor of State, when they are exercising the pardoning powers, or when a mercy petition is applied to the President of India or Governor of India, just read the article 161 and read the article 72 carefully. Here the President and Governor are having these powers, they are having the different powers under these articles, like pardoning power, commuting power, remit and also respite, reprieve. So this remission, respite, reprieve and commute, pardon, these are the different powers that you can study in the polity. But when they are exercising the powers, you should be very careful, like these things will be exercised only where the state is having that executive jurisdiction and where union is having that executive jurisdiction. That means President of India will exercise its power where the union's executive power extends, and state governor can exercise the power where state government extend its executive power. So within that limits only the President and Governor of President of India and Governor will exercise their powers. Now when these mercy petitions went to the President of India, actually lot of cases were filed on them. They are under union law, and CBI and the national level agencies are investigated that. So, and even if you want to pardon even a death sentence, governor cannot do. Okay, governor can go for other commutation, remission, respite, reprieve, but governor cannot pardon the death sentence. So that is how it went to the President of India in the year 1999. When it went to the President of India in the year 1999, President of India could not take any decision on that because of the delay in the year 2014. In the year 2014, Supreme Court has commuted that death sentence into the normal imprisonment. Now when this happened, the then Tamil Nadu government, please try to understand the sequence. Then Tamil Nadu government, decided to remit their sentences. So what is the meaning of remit? Remit in the sense they don't change the character of sentence, but that reduce the sentence time period. So that means they wanted to reduce it to zero and they want to release. That is what their intention actually. So Tamil Nadu government decided to remit. But when Tamil Nadu government decided to remit, Tamil Nadu government approached the union government. Union government. Why Tamil Nadu government approached the union government? Because of one reason. See, in the constitution, the President of India and governor is having their own respective pardoning powers under Article 72 under Article 161. But apart from that, in criminal procedure code, the state government can directly provide this relief to the convicts. So they will also provide the relief to the convicts, and the sections 433, 32, 433, 434, 435, these sections deals about this section. So this particular section deals about this power to commute the sentence, and this power is given to the appropriate authority. They mentioned in the act like appropriate authority. And under section 435, if any convict was convicted in a case, and that case, if it was probed by, investigated by either CBI or any other national agency, or if that case involves the damage of property of union government, then before you take any decision with respect to commuting this sentence, then you must approach the union government, and union government concurrence is necessary. This exactly this sections of criminal procedure code says. Now you must understand, one is under the constitution, the President of India and governor of a state can go for this, and under a particular statute, that means criminal procedure code, the state government can do that. The difference between the first one and the second one is, in the first one it is a union government and state government will recommend the both president and governor to take an action on that, but in the second case, when they are exercising the statutory power, state government can directly do that. So one is a constitutional power, second one is a statutory power. Now the state government want to use this statutory power, because already this death sentence is converted into a life imprisonment. So that is why the government want to remit that life imprisonment to maybe zero, and they want to release, and government use these statutory provisions, and under section 435 this case was probed by the national agencies. So because under TADA Act they were prosecuted, and because of that they want to take the permission of the union government. Then immediately union government went to the Supreme Court on this decision. The state want to release, perhaps that is not the right way of releasing the people, and they went to the Supreme Court. When the case went to the Supreme Court in its judgment, they have clearly mentioned like, now under the statutory provisions, the state government cannot release them. The whole jurisdiction lies with the union government, because the case involves some national agencies and TADA Act is involved in this. So because of that, the Supreme Court has given a clear-cut judgment like state don't have that power. Under this statutory provisions of criminal procedure code. Later what happened is, this Perarivalan, he approached the Tamil Nadu governor to remit his sentence under Article 161. That means here they used a legislative power, but here he approached the Tamil Nadu governor to exercise the constitutional powers. Now you may get a question, sir, when exercising this constitutional power, the jurisdiction always matters, and you already said like this person is convicted under a union law, and how can a state governor issue pardon, or how can a state governor issue any remittances or commuttance to that particular person? But he approached, I will come to that, he approached the Tamil Nadu governor. Then Tamil Nadu governor did not take any decision. Tamil Nadu governor did not take any decision. When Tamil Nadu governor could not take any decision, again this Perarivalan went to the Supreme Court again. The Supreme Court in the year 2015 he went. In the year 2017, the Supreme Court has given a parole, and in the year in that parole order they said like whatever the sentence that this particular petitioner or this Perarivalan is undergoing, Supreme Court divided his sentence into two. One is under central laws, that means under union laws the sentence, under state laws the sentence. One is under the central laws, whatever the punishment that he can get, that he has already completed. He already completed that sentence under the central laws. Now he is in jail. Because of IPC section 302 that led to murder. That means now he is only enjoying. In the jail under IPC 302. So the state is also having the jurisdiction. Then the Supreme Court said like the appropriate authority can decide on this mercy petition. That's what exactly the Supreme Court said. The central whatever the punishment that is awarded under central laws has completed. Now he is in jail because he must complete the sentence under 302, that punishment for murder. Then the Supreme Court said now this is an appropriate authority, so the appropriate authority can take a decision. After this judgment, immediately again Tamil Nadu Chief Minister, the then Chief Minister Edappadi Palaniswamy, again he recommended, the entire cabinet has recommended to the governor to give that remittance under Article 161, to remit the sentence under Article 161. So earlier in 2014 Jayalalitha was used the statutory power, but here the Chief Minister, Tamil Nadu Chief Minister Edappadi Palaniswamy used constitutional powers. And when this was sent to the governor, that recommendation to release this Perarivalan, governor sits on that. That means governor did not take any decision initially on that, and later governor sent this to the President of India. And why governor sent this to President of India, I will come to that little bit late. Now after that they could not take any decision on this. And finally Supreme Court intervened into this. Supreme Court has already given an order that appropriate authority is having a decision to decide anything on this particular case, but appropriate authority is not deciding the case. So I am intervening, and the Supreme Court used Article 142 of the Indian Constitution in extraordinary case in order to do the complete justice. The Supreme Court can use that provision, and according to this provision the Supreme Court has given an order to release this particular person called Perarivalan. So now in this whole entire episode of the point 1 to this, there are lot of constitutional and other legal disputes are there. Now I will put each and every question one and I will try to answer it. See, the newspapers are confined to only one aspect of the issue, that is the federalism. See, the first one is role of governor. So I am just keeping this like this only, otherwise you will confuse. First one is role of governor. See, the role of governor starts only here. The role of governor not came into picture till this point, and role of governor came only when the Supreme Court has given its judgment, and this judgment came in the year 2018. In the year 2018, that means the role of governor starts only after 2018. So after 2018, what happened is the Supreme Court has given a judgment that appropriate authority can take a decision on that mercy petition, and whatever this particular case that under which he is in jail comes under the jurisdiction of the state also. That is why state cabinet has recommended to the governor. When a state cabinet is recommended to the governor, what are the options that are there in front of the governor? In front of the governor, there are some options like he can agree or he can disagree, and if he thinks that there is a constitutionality involved in this, he can send it to the President of India. But under this, what type of constitutionality is there? Because Article 161 clearly says that it is only related to the state, and governor will exercise those power on the recommendation of the cabinet, and this governor could have acted on this 161 either to agree or to disagree. But governor did not act because the constitution don't stipulate any time period to act. So that is why he has not acted, and moreover he sent this to the President of India, which he is not supposed to do that. Under Article 161, the governor cannot send it to the President of India, but governor did it. That means the governor has not acted on the advice of the Council of Ministers. First point. Second one is governor has sent it to the President of India. He should not have done that. These are the two things that the governor has done something wrong. That is why Supreme Court intervened. So the role of governor is when a state government is recommending for something, then the option lies with you is to agree or disagree. But you can't delay it, because the constitution has not stipulated any time before which you must act. That doesn't mean that you can sit on that for any amount of time. And moreover, where there is no provision to send it for the consideration of the President of India, you must not exercise it, but the governor exercised it. So that is the role of governor. So the governor role has started here, and governor committed those two things. That is the reason why Supreme Court has given an extraordinary judgment. Next, when it comes to the role of president and federalism. See, when this was sent to the president, and president as a protector of the constitution, he could have immediately sent it again back to the state governor that this is not under my jurisdiction. Under federalism or under the Constitution of India, Constitution clearly stipulates that you are having the exclusive power under Article 161, you no need to send it to me. Because already there is a Supreme Court judgment that under this appropriate authority can take the decision. And the President of India could have done that in order to protect the federalism. But when a Supreme Court already clearly stipulated that appropriate authority can take the decision, and these people, both Governor and President of India, they did not allow the state government to perform its functions. So that is a violation of the federalism under this particular case. So now you understood governor's role, President of India's role, and how federal principle has violated in this. Next important aspect of this thing is the executive jurisdiction of union and state when a case is probed by the central agencies. See, there are two types of powers under the entire administrative setup. One is under the constitution, president and governor both are having the pardoning powers, and they can receive the mercy petitions. So that is constitutional thing. Now what happened is if you looking into the case, in this case the persons are arrested and convicted under both central and state laws. Because of this both central and state laws, either center or state could not take decision completely. The center can take that decision. See, under the legislative provisions of this criminal procedure code, the act clearly says that if the case is probed by the national agencies like CBI, then the state must consult the central. That means initially the government of Tamil Nadu has thought that I must take the concurrence of union government, without that I can't exercise my power under this particular legislation called Criminal Procedure Code. But after some time the Supreme Court said like, no, the punishment under central laws is completed. Now he is under a particular law which comes under the jurisdiction of the state. Now the state can also take a decision. That means the Supreme Court initially they said like you are not supposed to release, but the same Supreme Court said like you can take a decision. Here the Supreme Court said like state cannot take decision, but here the Supreme Court judgment is like state can take decision. Why this dichotomy? This dichotomy is because a person is convicted, he was convicted under both the central laws and state laws. Once his punishment under central laws is completed, now the state got that jurisdiction. So that means now the state and center, when concurrently having the jurisdiction, when one authority, that means union government, don't want to release them, but state government want to release them. So this is the conflict in this Perarivalan case. So in this Perarivalan case, the conflict is this: both the laws are involved, and your legislation says that when a case is probed by the central agency, the state must consult the union. And because of that, state could not take a decision. But after some time, when they have completed the imprisonment under the central laws, now they are under the prison. They are in the prison because of this CRP, because of this IPC 302. State is also having jurisdiction. State want to release them, center don't want to release, because it is going to have its implications at the national and international level. So who exactly are having this jurisdiction in this particular case? Initially they said like only union, but now you said state and union. So perhaps when it comes to this jurisdiction, when we are filing the cases, perhaps we must file the cases in such a way that it should come completely under one jurisdiction. That too in an extraordinary heinous cases, not in all cases, because again if you take away the jurisdiction of the state, it is against the federalism. But at least in extraordinary cases, you must file the cases in such a way that it should come under the jurisdiction of one entity, so that you can avoid this problem. So this is something about the executive jurisdiction of both union and state, the concurrence sometime. Okay, and the next important aspect in this case is the overreach of Supreme Court in using Article 142. And this, with respect to Article 142, the question was already asked in UPSC prelims. And under this Article 142, the Supreme Court, in exercise of its jurisdiction, may pass such a decree or to make such an order is necessary for doing the complete justice. So to do the complete justice, the Supreme Court can pass any order under Article 142. Now the point is, why the Supreme Court is overreaching? Is it not the overreaching of Supreme Court, overreaching of judiciary, when the laws are there, when both the entities at the union level and state level is there? Why Supreme Court intervening, and that too when the entire issue is in process? Why Supreme Court has intervened? The Supreme Court said, and some people call it as an overreach of judiciary, some people consider it as, no, these people are not allowing that person to enjoy his rights under the law. That is why Supreme Court intervened into this. See, the Supreme Court intervened because the state and the center, that means the state and the union, they are at the crossroads. That means now they are completely antagonizing. That means they are completely taking a diametrically different view on this case. Because one authority wanted to release, one authority don't want to release. And moreover, there is a concurrent jurisdiction that is there here. Because the Supreme Court earlier they said state cannot release, but but now in the year 2018 the same Supreme Court said like he can be released if appropriate authority takes any decision. That means when such a confusion is there whether to use this legislative powers in the year 2014 or to use the constitutional powers in the year 2018, in order to settle down that, the Supreme Court intervened. So it's not a Supreme Court overreach. Whenever there is a confusion in the laws, whenever there is a confusion in applying the legislative and constitutional provisions, whenever there is a concurrent jurisdiction of both state and union, and one authority takes a decision and another authority is taking a decision which is completely against to the decision taken by the first authority, then in order to settle this dispute, and that too it involves with the freedoms of the individual, and that too they are having that legal rights, that is why Supreme Court intervened in this particular case. Be careful, Article 142. Why Supreme Court has used this Article 142? It's not an overreach in this particular case. Okay. Next. Now the simultaneous usage of the simultaneous appliance of the constitutional and statutory powers. See here till this point the the Tamil Nadu government used the legislative powers, that means Criminal Procedure Code power, which has given the power under section 435, but again after that they have started using this Article 161 of the constitutional power. See, when they want to use the legislative power, there is no problem, because the legislation don't permit the state government alone to take a decision on this remission of sentence of the person, because 435 says that the concurrence of union is required if it is proved by the national agency. But when the Supreme Court has given a judgment in the year 2018, state want to apply the constitutional power, center want to apply the legislative power. Why governor actually forwarded this to the President of India? Not that governor is ignorant, because earlier this case was dealt under a legislation, that means CRPC. Tamil Nadu government already tried. So now what they thought is, if the governor is having the power, if the state government is having the power under Article 161 to release that, union is having an every power not to release under the legislation called Criminal Procedure Code. So that means simultaneously both constitutional provisions and legislative provisions are contradicting with each other. Union want to use the legislative power, state want to use the constitutional power, and which prevails? Which one prevails? Normally when a legislation and constitution both are in conflict, constitution prevails, the constitutional provisions prevails. That is the reason why Supreme Court upheld the constitution provision, not the legislative provision, of Criminal Procedure Code. Okay, so this is one thing that you must understand, this conflicting of the constitutional power and legislative power in this particular act. Okay, next. The another important aspect of this case is the procedure established by law versus national security. Procedure established by law versus national security, or you can call it as rule of law versus national security. See, the point is, these people, and it is only related to one person, and the same logic may apply to the remaining people, and remaining people may also ask for the remission and they can be released. But the point is, these people are involved in the assassination of former prime minister of the country. And when a former prime minister was assassinated, and after some sentence, if you release these people, what type of message that we are going to send it to the world? That is what the national government is concerning. The government at the national level thinks like it is going to have the international implications. This government has released everyone who assassinated the former prime minister of that country. That is not a good signal that we send to the world. So that is the reason why national government is seriously thinking on this, and they don't want to release it. But in this Perarivalan issue, there is an excuse. The excuse is that the Perarivalan has involved in purchasing a battery and he has given to the Shivarasan, who is key person in that. But he don't know, that means Perarivalan don't know that these batteries are going to be used for the assassination of Rajiv Gandhi. So you can excuse that person, but if you apply the same logic to all and if you release everyone, you are following the procedure established by the law. So what law has its own course, we are following, but at the end of the day, after following the entire procedure, you are compromising your national security. You are compromising your national security. So when constitution rights are there, these people approach the President of India with mercy petition. President of India has made inordinate delay, and because of the delay they commuted it to imprisonment. After that, government want to release it, but Supreme Court said no, the law don't permits. Again he go for governor to exercise the constitutional power under Article 161. Again he could not take decision and he delayed it. Again he went to the Supreme Court. Supreme Court clearly says like there is a provision you can do that, and after that the state cabinet has passed a resolution and sent it to the governor, and governor again sent it to the president, and they also delayed the thing. That is why Supreme Court intervened. Here nowhere it is a violation of the law or a violation of the procedure. Every procedure we followed, but ultimately we are end up in compromising the national security. So this is a very serious thing. That means when national security is also equally important along with the procedure established by the law. One should not take over the other. One should not get the primacy over the other. And the point is, whatever the legal remedies are there, that must be useful, but at the same time you must also concern about the national security. Perhaps okay, once the Perarivalan has released, but when it comes to the other people also, perhaps that is not going to send the correct signal. So in the procedure established by the law, in that procedure, people who are exercising the powers in that procedure should also be concerned about this national security and the impact that it is going to have on the national security. Okay. This is another aspect. Now there is another important aspect in this case is misuse of constitutional powers to curtail the individual freedoms. That means governor is having some constitutional power. When a mercy petition is filed in front of the governor, the constitution has not clearly stipulated that within how much time you can take a decision, but here you made inordinate delay, and here President of India made delay, here governor made delay, and the courts are obviously having their own delays because procedural delays. So the procedural delays and the delays of the constitutional authorities when they are exercising the constitutional power, and ultimately this person has freed in the year 2022. Is it not violation of the individual liberties because of the misuse of discretionary powers that you have? Because these discretionary powers are given to you without stipulating anything, because the constitution has put faith on you, and you will be you are the right person, you will take the appropriate decision because you are enjoying a ceremonial position. It's not an appropriate thing to put some time limits on you to act, because you are the protector of the constitution, you are the one who upholds the constitution. That is why the constitutional framers and the constitution has put faith on you. But you misused some of the provisions, you delayed the things because constitution has not stipulated, and because of that individuals are losing their freedoms. So the question may arise, if today it happened in a very severe case of Rajiv Gandhi assassination, it has its own implication on national security. Tomorrow it can happen with any other case also. That is the reason why there may be a question that is arising like, do we really need to codify the discretionary powers of the constitutional positions? When they are making inordinate delays, that delay lead to not only injustice but also the violation of the liberties and rights and freedoms of the individual, then definitely a question may arise, should we really need to codify the discretionary things in the constitution to make full justice and to make the people to enjoy their fundamental rights? So these are the different aspects of this case. These are the different aspects of this case. Be clear, just have an idea about the basic facts of this case and try to understand each and every point that I have mentioned. And these are the different intricacies involved in this case, from the governor to the president to the Supreme Court to the concurrent jurisdiction to the contradictory of the constitutional and legislative provisions to the national securities to the individual freedoms. So these are the different aspects involved in this, and you may get a question on any aspect. Don't think like when a particular incident or issue happened, the question will be straightly on that thing. No, they may not give direct straight question on that issue, but there are many things that are associated with that case, and you may get a question on any other aspect. Okay, just have an idea and be clear about some of the things mentioned in this, and also the intricacies or the conflicts or the dichotomy that the Supreme Court has shown in different cases. Just have an idea. Okay, so this is something about the intricacies involved in the exercising the pardoning power, and with a case study under Perarivalan case. Okay, thank you.
Amrita IAS Academy.